Okay, welcome. We're doing July 2016 Professional Responsibility Question 6. And as you know, this is the 3-day bar because now they're not 6 essays, there's only 5. So first thing we do when we go to an essay, now everything that I train you to do is exactly the way you should do on the exam. Nothing changes. So before we go to the fact pattern, we don't start from the beginning. We go to the call of the question. The call of the question here says, what ethical violations, if any, has Len committed? Len is the lawyer, that's why they have the L there. It says answer according to ABA and California authorities. As you know, California is now pretty much in line with the ABA after the new rules that came out effective November 1st, 2018. So there's probably going to be very little distinctions. Of course, California has two things that I always stand out in my mind. They want everything in writing for the most part, and they want you to keep your mouth shut. So keep those two things in mind, and you'll pretty much be good with California and ABA. Okay, so when you're trying to figure out how to organize an essay, it's actually pretty easy. Just go in chronological order. Whenever you see an ethical violation, just discuss it, and we'll do that as we go on the board. Okay, Len, an attorney, is a member of Equal Ownership Incorporated, Equal, a nonprofit organization that seeks to help low-income families purchase homes throughout the state. Okay. Len does not represent Equal as an attorney. Okay, so he's just a member of an organization that helps low-income families purchase homes. All right, not bad. Equal helped to get a statute enacted that requires that all new residential developments contain a certain percentage of low-income housing. All right, so Len's participating in Equal. So his participation eventually ends up conflicting with his representation of ABC, which you'll see in a second. So paragraph 1 was just background information. There's nothing there. A lot of people think that every sentence, oh, there's always an issue in every sentence. Not necessarily, no, not at all, not necessarily. What happens is sometimes they have to set up the story. So paragraph 1 is just setting up the story. And by the way, as you're gonna later find out, or you should have already known, the most heavily tested topic by far in professional responsibility is conflicts of interest. Duty of confidentiality is right up there too, but conflicts of interest are the most important, heavily tested issue. You need to know it. Ironically, both duty of confidentiality and the duty of loyalty, which regards the conflicts of interest, apply in this essay, so this is a really good learning tool for the biggest issues. All right, so moving on. So Equal helped to get the statute enacted that requires all new residential developments. Okay, we got it. So Len participated. I'm assuming Len probably had something to do with that. Who knows how much he participated in that? Okay. ABC Development Company, ABC, is a corporation that wants to challenge the statute. The statute that Equal, that Len's a member of, helped get enacted. Pat, the president of ABC, asked Len to represent ABC, and Len agreed. All right, so he's representing the corporations. The corporation is the client, remember that. All right, we're gonna have that down here when we find out what's going on with members of the organization. Len does not personally agree with ABC's objective, but moves forward the representation nonetheless by filing a complaint challenging the statute. Okay, so remember, a conflict of interest. The first thing we're gonna do is we're gonna have a conflict because his participation in Equal is gonna conflict. His participation in Equal is going to conflict with his representation of ABC. And he does not even personally agree with their objectives. It's okay, you don't have to agree with your client. You can represent someone that you don't believe in their claim. Like I could represent somebody in a divorce that I think is a scumbag. But I'll make sure, you can represent a criminal defendant that you know is guilty. You can do that. You don't have to, maybe I didn't agree with what the criminal defendant did. Maybe they murdered somebody. Maybe they touched a child. Don't agree with that. You can still represent them. I personally wouldn't, but you still can. Okay, conflicts of interest. So we have to see whether or not there's a significant risk that Len's representation of ABC is going to be materially limited by his involvement with Equal. Now, it may or may not be a problem, but there's a potential conflict there, and you have to think about whether a reasonable lawyer would tell ABC to consent. Okay. So he moves forward with representation by filing a complaint challenging the statute. Don't forget, a lawyer may not file a frivolous claim, but this is a new and probably untested area of law. So you can actually go for an amendment or a reversal, a modification of existing law. That's not frivolous. Len personally thinks the statute is good law and secretly hopes that ABC is not successful in his lawsuit. So with the conflict of interest, we have participation and equal. Okay, so we have Len's, which should be Len's participation and equal. And the second part of it is his own personal interest. Think about it. He secretly hopes they're going to lose. So if he's secretly hoping his client's going to lose, can he provide competent and diligent representation with that thought? Now, I mean, I'm sure there's been criminal defendants and there have been a lot of attorneys before that have had clients go, I hope my client loses. My client's kind of a scumbag. But you have to diligently and competently represent that. So we have two different types of contracts. Len's participation, that's the responsibilities to a third person, and also number two, Len's own personal interest. So the examiners do expect you to discuss both. Okay, and secretly hopes they're not successful. He also thinks it's good law. So another issue that comes up is, and by the way, it actually doesn't matter the exact order that you put it in. The examiners don't really care. Now, if it's number 1, 2, and 3, make sure you put, number 1, you discuss what goes on number 1. If like number 1 deals with, apple, B deals with, banana, C deals with Charlie, discuss them accordingly. But here, it doesn't really matter. The actual precise organization is not going to really matter that much. So we have duty not to file frivolous claims. Okay. All right, so there we go. So we have one issue, there's two. We'll end up breaking them down to see what we have. Okay, and we're gonna go through the entire essay first and then we'll come back. And now one of the things that I strongly recommend you do also when you're reviewing and when you're on the exam, read the fact pattern at least 3 times, please. Don't read it once and then glance it over a second time and think you've read it. No. You can't possibly understand it. And you end up, when that happens, you'll end up writing about more stuff that's not relevant and wasting more time than if you went back and actually read it and pinpoint the important issues. So make sure you I read the fact pattern 2, 3, 4 times. So before you even watch this video, if you haven't done it yet, read the fact pattern 2 or 3 times. Hit pause now, make sure you go back and read it a few times, and then watch it. It'll make much more sense, and you'll get more out of it that way. Also, it's very important to read the answer and to review carefully. Okay. So duty not to file frivolous claims may make a good faith argument. Okay, moving on. During the course of Len's representation of ABC, the corporation, and you have to act in the best interest of the corporation, Pat informs Len that Pat, who's the president, that's what P stands for, president, has filed false reports with the state EPA regarding the disposal of non-hazardous waste. Non-hazardous waste for those that are paying attention. Okay, so now we have corporation, corporate client, and non-hazardous. So don't forget, in California, so this has to do, you're going to end up going to the duty of confidentiality. So corporate client, non-hazardous, duty of confidentiality. Now, is it likely to prevent death or substantial bodily harm? Or is it a financial crime? Okay, I'll tell you, we'll get into that in a second here. Because it's non-hazardous, the disclosure is only necessary to prevent death or substantial bodily harm. If it's non-hazardous, it's not going to do either of those things, so you have to keep your mouth shut. And financial crime, the lawyer's services were not being used to actually perpetrate the fraud. In fact, we want the lawyer just to challenge the statute. Len's responsibilities as the corporation has nothing to do with the filing of false reports, so Len can't say anything. That's the duty of confidentiality. It encompasses all information learned during the course of the representation, and you can't say anything about it. That's why lawyers have to keep their mouths shut from this. Okay, moving on. And Pat tells Len that he's planning to file another false report next month. And what I would do if I were Len is I'd urge Pat to stop disposing of the waste and not file any more false reports, because you can do that. You can't advise your client and act as a mentor. Filing a false report makes the person or his or her employer liable for a substantial civil crime. Aha. So now we have a corporate client, and it's likely to call you have to act in the best interest of the corporation. So Pat's the president, and now you have to report what Pat's doing because it's likely to cause substantial harm to the shareholders, the board of directors, and anybody who's above Pat. So what Len should do is report to a higher authority. And I think the only person higher than the president is likely to be the board of directors. And if the board of directors doesn't do anything, you know what Len's got to do? Eat crow. He's got to keep his mouth shut. He can't say anything because it's not going to prevent death or bodily harm, and it has nothing to do with a financial crime because the lawyer's services were not being used to perpetrate the fraud. So unfortunately, all you got to do is report it to the board of directors and go, hey, this is what Pat's doing, filing false reports. You guys are likely to get a substantial civil fine. The board of directors says, just keep your mouth shut. That's it. We're done. So if the lawyer knows that the organization is likely to be substantially injured by an action of an officer or other constituent, the lawyer must proceed as reasonably necessary in the best interest of the organization. Well, if the organization doesn't want to protect itself after your advice, what can you do? Len does not take any action with respect to the impending filing of the false report. That's okay. No ethical violation for that. No ethical violation for that. So because Len knew that the filing of the false reports could likely result in substantial injury to the corporation, he must act in the best interest of the organization, such as referring the matter to a higher authority, which we already discovered. Okay, so what ethical violations has Len committed? Well, he may have committed a few, he may not have. Let's talk about each one. Conflict of interest. So a lawyer must act in the client's best interest. And here the client is ABC, it's a corporation. So a lawyer may not undertake the representation if it's directly adverse or if there's a substantial risk that the lawyer's representation of the client will be materially limited by his interest to a third person or by his personal interests. So here, let's talk about the participation, like the personal interests of Len. So he secretly hopes that they will not prevail. And Len's also challenging the very same statute that he may have helped get enacted. So we have a potential conflict here. There is a significant risk that the representation of ABC will be materially limited by Len's own personal interest in making sure that the statute is not overturned. So the question now becomes, is the conflict consentable? Would a reasonable lawyer conclude that competent and diligent representation could be provided? And because we talked about competence and diligence, guess what? We're going to have the issue of the duty of competence. Whether or not Len can actually provide competent representation based on all the facts and circumstances. So think about it. Representation is improper when impartiality cannot be maintained. So long strong personal bias may prevent him, we don't know, may prevent him from considering courses of action that reasonably should be pursued on behalf of ABC. Since the relationship has already assumed antagonism, the possibility that ABC's interests can be adequately served by Len is not very good. At least in my opinion. You can conclude differently, it doesn't matter, as long as you discuss the two different types of conflicts. So, you may conclude that the conflict is unconsentable, you may not conclude so. It doesn't matter. In fact, on second look, I'm thinking, well, maybe it's going to be fine. He secretly hopes his client's going to lose. As long as he provides competent and diligent representation of the client, then it's consentable and he can totally represent them despite the conflict. The thing is that your conclusion, at least in this particular instance, does not matter as long as you discuss the two different types of conflicts. Now, the participation equal, it's the same thing. I mean, he's got a responsibility to third party. He's a member of the nonprofit organization. and it does seem that he has some type of unwavering loyalties to Equal, you may say that, hey, he's just a member of the nonprofit. It doesn't really mean anything, and he can totally provide the necessary representation and skill that is necessary. That's up to you. It doesn't matter how you conclude, the two different types of conflicts are important. Now we have the duty of competence. Should he have declined representation because can he adequately, properly, thoroughly represent this client to his best interests, for their best interests, even though he has these personal feelings that he wants them to lose? Again, as long as he can provide competent representation, he hasn't breached any ethical rules. But that's a discussion of whether or not you think he has or has not. Okay, now the duty not to file frivolous claims. We know that a lawyer may not bring a frivolous claim. That's one without merit. However, a lawyer may make a good faith argument for a modification or reversal of existing law. So here, Len helped to get the statute enacted that his client wants to challenge. Well, I'm assuming he helped to get it enacted. Well, it says Equal helped to get the statute enacted. And if Len's a part of it, maybe he actually had something to do with it. The statute's new and untested, and there might be a strong policy argument to at least overturn it, or at least to amend the law. So, one thing is clear, Len's actions are not frivolous, even though he thinks they will not ultimately prevail. So the fact that he filed this lawsuit challenging a statute that probably may be valid, even though they may lose, does not mean it's frivolous, because it seems like there is a good faith argument for modifying it or overturning it. So that's what's the issue there. And again, don't focus so much on the conclusion, focus on the process of getting there. Why? Okay, this could be a good faith argument. Again, this is a discussion. The examiners are looking for you to be lawyer-like, not to memorize the exact wording of the language. No, they want to see how you're able to actually convey what's going on in this fact pattern in a legal sense. All right, moving on. Finally, when the corporation is the client, you must act in the best interest of the corporation. You have to report it to a higher authority if there's some shenanigans. And here, the false reports make the corporation liable for substantial civil fine. So Len must proceed in the best interest. So he should report it to the board of directors, and if they won't do anything about it, he may, but he's not required to report the violation outside, because this is necessary to prevent, actually, no, he's not. Excuse me. Okay, excuse me, he's not allowed to make, at least in California, he can't say anything. He just has to keep his mouth shut. Also, so he did not violate any ethical duties by not revealing the information. And finally, the duty of confidentiality, like we said, to prevent substantial death and bodily harm. There's no exception here for that because it's non-hazardous waste that's being disposed of, and it's not likely to cause any substantial death or bodily harm, so you have to keep your mouth shut under that one. And second of all, because Len's services were not being used to commit the financial crime, he's not permitted to reveal any information about the false reports. So this essay wasn't exactly the easiest one. It didn't contain a lot of facts, which means you're gonna have to add a lot to your analysis and be more creative in terms of what they're doing. I like longer fact patterns. They give you a lot more to play with. Anyways, the important thing is understanding how conflicts work, a conflict, personal interest, and responsibilities to a third person. You can't file a frivolous claim, but you can make a good faith argument for modification or reversal of existing law. You always have to be competent in representing somebody. You have to act in the best interest of the corporation. You have to report it to the highest authority if somebody is acting up, at least the higher authority, and if the higher authority doesn't act, then you might do it even higher. Confidentiality, generally you can't say anything unless you have to prevent death or substantial bodily harm, or to prevent financial crimes when the lawyer services were being used for those crimes. Anyhow, that's a wrap for question 6 from July 2016. There you go.